Hi, and welcome back to Military Law Talks. So, today we're going to talk about transgender in the military. So, transgender military service members. So, there's currently a lawsuit, and that we're going to talk about that lawsuit. But just to give a little background, so originally, transgender soldiers were allowed to serve openly under the Obama administration. So, previous to, and it was during Obama's second administration, so second term, right? So actually towards the end of Obama's term, so in 2016, but it went into effect in 2017. So prior to that, transgender service members could not serve openly in the military. There were a few that were in the military and undergoing gender transition, paid for out of pocket on their own, and sought there was a few testified in front of Congress and sought exceptions to policy to be able to continue serving in the military, because at the time, based on medical accession standards, they were barred from military service. Now, the Obama administration changed that and allowed transgender service members to serve openly in the military. And then Trump was elected. And so Trump took office in 2017, January of 2017. The policy that was enacted under the Obama administration went into effect in June of 2017. And if you were in the Army at that time, I was. If you remember all the briefings that everyone had to go through, that got training on kind of sensitivity training and pronoun usage. And I just remember there was a lot of consternation about that training. But, we adapted. And then the Trump administration decided to issue a study and change course. So transgender service members were allowed to serve. And then under the Trump administration were no longer allowed to serve without an exception. Then the Biden administration came in and reversed the Trump administration and essentially reenacted the Obama era policies. So we're going back and forth. And now, new Trump administration, Trump 2.0, immediately one of the first executive orders he signed was essentially banning transgender soldiers or service members from the military service. And then within 30 days of Pete Hegseth taking over as Secretary of Defense, put out a memo that effectively were barring transgender service members from service, but offering that if they voluntarily leave service, they could get separation pay up to 2 times what normally would be offered, wouldn't have to pay back any of their bonuses that have already been paid, regardless of any active duty service obligations that they have. They could leave the service voluntarily, or they could be subject to involuntarily separation. So immediately, literally the day after that memo came down, a lawsuit was filed. And recently on March 18th, there was a nationwide preliminary injunction issued in that case, effectively stopping the Trump administration from taking any actions in regard to not only the plaintiffs in that case, but all transgender service members, to also include people who want to enlist or join as an officer to come into the military. So also not only currently serving, but accessions, not stopping those accessions. So we're going to get into the lawsuit and that preliminary injunction. And so let me pull it up. All right. So this case is in the United States District Court, District of Columbia. So I'm going to off the bat point out that the District of Columbia is pretty biased against the Trump administration. And so not this opinion is, nothing, no surprises, right? And so in this case, there's several plaintiffs, but this is the named plaintiff against the United States. And like I said, in the District of Columbia. And so the opinion explains what I talked about, kind of the history, etc. This executive order that was issued by President Trump, Trump 2.0, and then Pete Hegseth's policy that essentially disqualifies transgender service members from service. There are some exemptions, but as the court points out, none that apply to the plaintiffs in this case. The judge in this case, in reading this opinion, it really felt like the judge was essentially arguing for the plaintiffs. It was incredibly biased opinion, but essentially arguing that this is like a civil rights issue, that barring transgendered is very similar to, right, first minorities, then women, then gays, fill in the blank. Now that blank is transgendered service members. And so that's, the court says that essentially that the Trump administration and Pete Hegseth has this animus against, and this bias and discriminatory animus against transgender service members, and that is partly why they have this ban in place and why she granted the preliminary injunction. All right. And so one thing that she says is that the reasoning that the government gives is because transgendered persons undermine military readiness, disrupt unit cohesion, good order, and discipline. Now, I am going to just put my own opinion in here, and I'm going to say that this is a hard argument for the government to make because transgender service members have been serving for several years now. So the Biden administration reversed the policy very early on in the Biden administration. So some service members have been serving for a very long time. And so it's kind of a hard argument to make. I think a better argument that they could have made is that transgender service members, they should have changed the medical requirements and said that they're medically disqualified from serving or not deployable. So therefore, that has a readiness impact. For example, like people with flat feet still aren't fit for government service, for military service without a waiver. There's all kinds of conditions that require waivers for medical conditions. And so I think an easier argument could have just been making that argument. But for whatever reason, the government didn't make that argument. Again, giving some history behind the order. The judge goes through this, gives some information, some from the transcript from the hearing in this case. And I gotta say, something that was really evident in reading this opinion is that the government lawyers seem to be pretty unprepared. At least that's how the judge made it out to seem. And I've only read the judge's opinions. I didn't read the briefings, so full disclosure. But it seemed like the defense counsel wasn't a zealous advocate for the government. And so this is a DOJ attorney that would be arguing this case. And so in several times, right, they'd say like defendants agree, or, defendant had no answer, defense counsel they called no witnesses. They didn't cross-examine. They didn't require the plaintiffs to call any witnesses to be cross-examined. So there were no witnesses called. It was just oral arguments. And maybe the government attorney realized this is kind of pointless. We know how this judge is going to rule. They're going to rule against us. So let's really put all our efforts into the appeal. And maybe that's it. Or maybe this particular DOJ attorney, maybe they don't agree with the Trump administration, and maybe they actually want the government to lose. I don't know. I'm speculating here. I can say that in most cities or counties, when a new district attorney is elected, all the attorneys in the office submit their resignation, and then it's up to that new DA to decide who to keep and who to let go. That worked for, the the losing party, right? The candidate who didn't win re-election, and that isn't done for the federal government. So a lot of these DOJ attorneys may have been hired under the Biden administration, and particularly in DC, I'm going to just be perfectly frank, most attorneys are really liberal, particularly in DC. So I mean, there are some conservative attorneys, libertarian attorneys, but unfortunately, attorneys kind of skew liberal. So who knows? Again, I'm speculating here, but that was something that kind of was obvious in this opinion, that the government attorney kind of didn't really seem as prepared as they should be. One thing that I want to point out, so the judge in this case argues that transgender soldiers didn't have any, or transgender service members didn't have any impact on recruiting, unit cohesion, military readiness, and they've actually improved since 2021. I'm going to say that that's obviously false, because the military has had a serious recruiting problem the last several years. The Army itself missed goals by 40%, which is like unheard of bad. The Army and the Navy actually lowered their recruiting measures to meet measures. I think the only service branch that actually met recruiting and under the Biden administration was the Marine Corps. And so this is just like an obviously not an accurate statement. But again, arguing that that the plaintiffs, the whole opinion is very skewed towards the plaintiffs. Obviously, the plaintiffs won at this level. But I do want to point out this order, this temporary injunction, preliminary injunction, does not go into effect until March 21st at 10 a.m. That allows the government attorneys time to file an emergency stay with the DC Circuit. Now, this could be overturned on appeal, and so I will follow this case, and I will provide an update video when and if this case is overturned. All right, so again, so I'm not going to go through this whole opinion. I will go through some highlighted portions. I will link this opinion below, and you can read it if you'd like, but otherwise, I'm just going to go over some highlights. So, like I said in the beginning, this judge really makes it out to be a civil rights issue. And so, in this opinion, right, the court's opinion is long, but its premise is simple. I'm reading from the opinion. It in the self-evident truth that, quote, all people are created equal. All means all, nothing more, and certainly nothing less. And so this argument, the plaintiff's argument is a Fifth Amendment equal protections argument. So arguing that they are being treated differently than other service members, and for that reason, it's violating their constitutional rights. And so the case goes through all the background of, the transgender policies in the military. Yes, they can serve. No, they can serve. And the justification for those policies and the change of the policies. And again, like I said, it's a hard argument for Trump 2.0 to make that service members, aren't fit for service, or that they have impact on readiness or unit cohesion, because they have been serving for the past 3 or 4 years. And so it's definitely a harder argument to make than under the first Trump administration, which that ban on transgender service was eventually upheld by the courts. And so there is precedent for this ban. However, like I said, it's a lot harder of an argument now that transgender service members have been serving for the last several years. So more on the history, more on the reasoning of both, the policy allowing and then the policy banning. And so more on that. I'm going to skip further ahead just for time's sake. So I'm going to skip more to like the argument portions. This is Background information. And all right, so this is the history of this case, the litigation in this case. And so it was actually, I was wrong earlier in the video. I said one day after Pete Hegseth's memo. It was actually one day after Trump issued the executive order. There was this complaint filed, but there were multiple amendments. So currently we're on the third amended complaint, and that is what the court is making this decision on, and that third amended complaint. And they were making amendments, based on new policies coming out from the Trump administration. All right. And so the plaintiffs, reading from the opinion, this is a quote, the plaintiffs allege that the military ban, quote, from the plaintiffs, rather than being based on a legitimate government purpose, like medical readiness issues, deployment, etc., instead reflects animus, I'm quoting again, towards transgendered people because of their transgendered status. They claim that the military ban violates the equal protection component of the due process clause of the Fifth Amendment. And again, the judge, spoiler alert, agrees with the plaintiffs on those issues. And so this is, again, kind of pointing out that I felt like the government really wasn't as prepared. So the government didn't present any affirmative witnesses, didn't call any witnesses themselves, didn't force the plaintiffs to call their witnesses to be cross-examined. So the plaintiffs didn't call any witness either. And then there was oral arguments over 2 days. And then there was a hearing in February. And then this ruling came out in March. And so this is talking about Pete Hegseth policy issues. Something that the court pointed out was that previous policies took months or sometimes even a year or more to develop based on a working group or based on recommendations, whereas the Pete Hegseth policy memo was issued within 30 days of him being SecDef and didn't provide a whole lot of evidence or reasoning for the decision. And quoting from the policy says that any service members who have a current diagnosis or a history of gender dysphoria are no longer eligible for military service. And so the departments should begin separation actions. And like I said, they can voluntarily leave service, or they can request a waiver, or they'll be involuntarily separated. But again, right now, this is all paused because of this preliminary injunction. All right. And then it talked about there's an exemption for this policy, but the court argues that essentially no transgender service member would meet these exemptions because you have to be stable in your birth sex, never attempted a transition, and is willing to adhere to all standards associated with the birth sex. So essentially, in the court's mind, an argument that, well, that wouldn't describe any transgender individual. All right. And this is talking about the pay, right? So they get twice the service members' involuntary separation pay. And I'm going to say this is a really, really generous policy. I have never seen anything like this where it's allowing double what the voluntary separation pay, not having to pay back bonuses or anything else. So that is pretty generous. And I'm going to tell you, I'm going to compare this case a lot to service members who were involuntarily or voluntarily left the service due to not wanting to take the COVID vaccine, and nothing like this was offered for them. So, and the courts were openly hostile to those service members, even the ones claiming First Amendment religious exemption, whereas this court is incredibly favorable. Sorry, my dog is barking. Incredibly favorable to service members. So there's definitely a bias. And so talking about, again, the policy. So we'll get into the bulk and the argument section of this this opinion. And so one thing is that there's some argument about terms. And so Pete Hegseth, they point out that he has a public announcement that transgender troops are disqualified from service without or without exemption. But the defense counsel in this case argues that the court should ignore those public policies, those public description of the policy, and that it's really should be gender dysphoria. The court rejects that argument and says, I presume that the Secretary of Defense is making an accurate policy proclaimment when they make a public statement about a policy. And so I kind of agree. Like I said, I feel like messaging hasn't been great, and some messaging and statements made not only in this case, but also by Elon Musk in a previous case about Doge and USAID, that a lot of seem to be undisciplined public statements that seem to undermine the government's arguments in later litigation, that there needs to be a little bit more messaging but to keep government officials on point. And so that's just one example of that. All right. Again, arguing that it's essentially effective in a ban on all transgender service members, and that exemption is really just kind of in name only. So this is a witness, former Assistant Secretary of the Air Force for Manpower and Reserve Affairs for the plaintiff. So this witness provided an affidavit, again, wasn't called as a witness, wasn't cross-examined on this, and notes that, quote, this policy was put together in a, quote, rushed and haphazard manner, issued and implemented. This was highly unusual. Again, I kind of disagree, because that's kind of how it felt with the COVID vaccine. It was pretty rushed as well. And then, again, a quote from that same Mr. Wagner, no relation, says that there's no other circumstances where service members with a treatable condition that allows them to deploy and meet all readiness standards are nevertheless deemed categorical incapable of service. That's a quote. And again, I'm going to say, well, what about service members with the COVID vaccine, right? There was no reason that they were essentially at little to no risk of COVID. We knew very, very early on that low vitamin D left you vulnerable to COVID. So the military could have just given everyone vitamin D and ordered everyone to take vitamin D and move on out. But that, like I said, I categorically disagree with this statement, because there was another circumstance, and it's very, very recent, was that anyone who didn't take the COVID vaccine was automatically not deployable and automatically didn't meet readiness and automatically immediately, not only they were separated from the military, but also given bad paper before they separated from the military, given some of them letter of reprimand, some of them were court-martialed. And so for, not obeying with a lawful order. And so this recently happened. The last administration did this. So I disagree with this statement. But unfortunately, this statement was never cross-examined. This statement was never rebutted by the government attorney. All right. And then there's some talking about the additional costs with medical expenses. And the judge argues that the government doesn't really provide a whole lot of support for this. There's another portion of the opinion that talks about that they didn't have the data to know how many transgendered service members are in the military, which I was shocked about. We should easily be able to come up with those numbers. Also, there's a part in the opinion where it said that the government attorney couldn't identify how many service members have been diagnosed with gender dysphoria. Again, should be really easy. We have data, and we have all military members have electronics health records. It's really, really easy to pull the codes, the diagnosis codes for gender dysphoria, and you could easily run that data and get that data. But again, like I said, I felt like the government attorney wasn't as prepared as they should have been. All right, let's see. The judge discounts all the evidence that the government relied on for this policy change. And so one of them was that transgender individuals are at a higher risk of suicide. And essentially, the judge just totally discounts that and doesn't accept that. Also, another thing saying that long-term studies show that regret rates are extremely low, though you can look on the internet, you can find all kinds of people who are detransitioners and who absolutely regret transitioning. So it definitely is out there. The judge is just kind of cherry picking the data that supports her argument and her decision. All right. Again, they're talking about costs. The judge argues that these costs are minimal. Doesn't take into account the cost to separate them. This is a quote from the opinion, nor do the defendants analyze the cost of discharging and replacing thousands of trained service members, many with decades of experience and specialized skills. Again, I want to point out the courts did not seem to care when the military was kicking out individuals, highly trained individuals. There was a case of over 26 Navy SEALs who did not want to take the COVID vaccine, and their case on preliminary injunction even went all the way up to the U.S. Supreme Court. And it was unresolved because of the change of policy that Congress, took away the vaccine mandate. But the courts didn't seem to care that the military was kicking out highly trained individuals. We've put, like Navy SEALs, we've put hundreds of thousands, if not $1 million plus, into training them. And you can't just pick someone off the street and make them a Navy SEAL. It takes a long time to train them, to invest in them, and not most people wash out. So you'd have to find those individuals who can actually pass the training, and those are far and few between. So this argument rings really hollow for me because, again, these courts did not care when it came to people who were claiming religious exemptions against the COVID vaccine. The courts showed them no sympathy and didn't really care that the Army or the military was kicking out those individuals. So that's, again, it really, really shows the bias of these courts. Again, saying that the government didn't provide enough evidence. That's a common theme. Saying that, hey, we have high-ranking military leaders who testified or gave affidavits to the plaintiffs, but the defendants only had one affidavit on their side. Again, hey, it's a little concerning that the government wasn't more prepared for this case. All right, I'm going to skip a lot of this stuff for time's sake. Let's see. Again, talking about, hey, defendants concede that they have no evidence to contradict these assertions. Common theme, the defense counsel didn't seem prepared. And so, again, the judge is going through the standard review, going through the argument. There's a couple things. So they're arguing that this is sex-based discrimination, so it should get what's called intermediate scrutiny. And so it's a little higher level of scrutiny. The government's arguing that there shouldn't be a nationwide ban, The judge obviously disagrees with that and gives her reasons for that. I think there's a few other things that I wanted to point out. All right. And so this is what the government is arguing, that the reasoning for this ban is military readiness, unit cohesion, good order and discipline, and disproportionate costs. And again, I think it would have been a better argument to make is purely on like a medical argument to say for medical reasons, transgender service members cannot serve. I think that would have been a better argument. The argument about military readiness, unit cohesion, good order and discipline, it's a lot harder of an argument to make because they've served, for the last 3 or 4 years. And so, and the judge points out that is kind of a hard argument for the government to make and doesn't buy the argument. All right. Let me see if there's any other. Yeah, so this testimony, which the defendants do not rebut, again, they seemed unprepared, that the military, right? We've had transgendered service members serving openly for the last several years. We've been able to assimilate them and have no issues with them serving. They're talking about costs. She's arguing that the costs are minimal for transgender service members, their medical costs. Now, I think that could be debatable, but the government didn't seem to have evidence that rebutted this. For example, she points out that Viagra costs the DoD $41 million, which I'm like, that's insane. I don't know if that's accurate or not, but if it's true, that's terrible. I don't know why. That's nuts. But nearly 8 times what she's saying that we spent on transgender medical care. Again, I don't know if that's accurate, but it doesn't seem to be rebutted by the government attorney. All right, so it is a real long opinion coming towards the end. All right, so she's arguing that the defendants are not going to suffer any harm if the preliminary injunction is put in place. And I actually agree with that because it will keep the status quo. Like transgender service members have been serving for the last, 3 or 4 years openly. So obviously having the preliminary injunction it's not going to change anything that's already been happening. She talks about defendants provided no testimony. And so, yeah. Sorry, my dog is barking. All right. And then here, this is an important point that I wanted to point out where the judge is totally wrong. So it says, if they opt for removal proceedings, and this is a quote from the opinion, they may be dishonorably discharged and per the Hegseth policy will be required to repay the military their bonuses and other amounts. So part of that is totally false and some of it is true. So in the policy memo, right, if service members voluntarily leave, they don't have to pay back their bonuses. They get double the voluntary separation. But if they choose to be involuntary separated, then they would have to pay back their bonuses and other amounts. Now, they wouldn't be dishonorably discharged. And this is where I get really frustrated when people get this wrong. So the only way service members can be dishonorably discharged is by a court-martial. So that is a punitive, stigmatizing discharge that can only be given to a service member. And it's really only enlisted service members because officers there's a dismissal by a general court-martial. There's 3 levels of court-martial and only one of them, the general court-martial, can give a dishonorable discharge. So the lowest level of discharge, that characterization of service that a service member could get while being administratively discharged, is an other than honorable. So there's 5 levels of discharge. There's honorable, there's general under honorable, there's other than honorable. Those are the 3 options for an administrative removal. So like involuntary separation, it can only be those 3. And then for like I said, enlisted soldiers, there's bad conduct discharge or dishonorable discharge, and those can only be adjudged by a military judge at a court martial. For an officer, they can be dismissed at a court martial, and that is it's a stigmatizing discharge. So that is a point that I want to emphasize, that the court was clearly ignorant of military and military law. All right, so the court is granting the preliminary injunction, but as I said, this preliminary injunction, while it was granted on signed, March 18th, 2025, it is not going to go into effect until March 21st, 2025 at 10 a.m. The defendants have time to file an emergency stay in the DC Circuit. Again, DC Circuit, they're pretty biased against the Trump administration as well. So I think, I can't be sure, but I would think that it would likely be affirmed on appeal at the DC Circuit, and this might have to go to the US Supreme Court. Now, originally under the Trump administration, the first Trump administration, that preliminary injunction for the reversal of the transgender, allowing transgender soldiers to serve, the ban on transgender soldiers, the preliminary injunction issue did go up to the US Supreme Court, and the US Supreme Court did reverse the preliminary injunction, and later district courts did find that the Trump administration was able to put that ban in place. Now, again, I think it's a harder argument to make this go around Trump 2.0. So we'll see what happens. I'm going to keep abreast of this case, and I will provide updates of this case as this case progresses. So if you are with me at this video, please hit the like button, share this video out there. I'll be posting shorter clips of this video, and I'll post the court documents in the links below. And so I'll catch you in the next video. Thanks for tuning in.